We're looking for Mr. Cosden. There he is.
Morning, Your Honor.
Recognize that face anywhere. All right, you ready to go?
Yes, Your Honor. We're ready.
I'm going to start the clock. I've got my iPhone today, which I think is as accurate as any other device. But if you think I've shorted you minutes, then please let me know. Here we go. You're on.
Good morning, Your Honor. Before the court is Williams versus State, 2D18-4434. I represent Mr. Williams, who is the appellant here. He was one of four defendants in the court below. This case arose when a pawn shop in Auburndale was robbed in January of 2015. A vehicle chase ensued. A vehicle allegedly occupied by four suspects from the robbery ran from law enforcement officers. At least one person in the vehicle shot at the officers who were pursuing. The vehicle eventually crashed. One of the occupants was arrested near the crash site. Another suspect fled from the crash to a house nearby. He murdered two people in the house, stole their car, and escaped from the house in that stolen car. Apparently, the car had been backed into the garage. He drove through the closed garage door with the car. Numerous law enforcement officers, one of whom was armed with an AK.
Mr. Cosden. Mr. Cosden?
Yes, Your Honor.
Oh, to me, you muted for a minute, but I was going to interrupt you. I intended to interrupt you, if you don't mind, because I think we are pretty familiar with the facts. Regarding the first-degree murder charge for the decedents in the house, Mr. Gordon entered. I just want to lay something out for you. So just assuming for the sake of that discussion about the first-degree murder charge based on felony murder, and assuming for the sake of discussion that Mr. Williams participated in an armed robbery in which he entered in a pawn shop armed, and one inference to be drawn was that they intended either to use the fact that they were armed to intimidate their victims, but also to shoot their way out in the event that they were at risk of being apprehended. What stops why couldn't a jury infer that the murder by means other than a firearm was in perpetration of the armed robbery because they were in a constant state of escaping from the scene for the purpose of applying, to convicting Mr. Williams of that homicide?
Well, there are several reasons for that, Your Honor. The first is there is no evidence, and I'll come back to this, but there is no direct evidence and only very, very weak circumstantial evidence that Mr. Williams was involved in the robbery in the pawn shop.
But I said assuming, because there is, we can get to that later. I just want to focus on this. Assuming that he was one of the perpetrators in there with a gun, and he and his compatriots had brought guns for the purpose of obtaining stolen goods by force, but presumably, and they seem to have demonstrated, also shooting their way out of a situation in which they had to escape apprehension by law enforcement. Was not Mr. Gordon still in the process of, in essence, using weapons to perpetrate violence in order to perpetuate their escape from the armed robbery?
Well, first off, Your Honor, there is absolutely no evidence that was probably Mr. Gordon who went in the house and did the murders. There's absolutely no evidence that Mr. Williams was ever in the house. In fact, shortly after Mr. Gordon escaped by driving through the closed garage door, the vehicle that he was driving crashed, and he was arrested at the site of that crash. There was no other person. The testimony was that affirmatively that there was no other person besides the victims and Mr. Gordon in the house. And there was no evidence that anyone was armed when they escaped from the house, or when Mr. Gordon escaped from the house, the murders were perpetrated by stabbing, not with a firearm.
But
Now-
but their escape was perpetuated by a series of events that utilized weapons to
Your Honor-
use physical force to escape apprehension for the crime that had happened, presumably moments. I don't know how long the escape lasted, but my point is, why is that not? What case law can you point me to that said that's not in perpetration of the crime that, for the sake of my discussion, Mr. Williams committed along with his compatriots?
Your Honor, in a case called Collins versus State, which is cited in the initial brief, in order for one to be guilty of a crime physically committed by another, he must not only have the conscious intent that the criminal act be committed, but he must also do some act to assist the other person.
But isn't that for a principle theory?
It could be applied to a principle theory, Your Honor. It also is directed generally to crimes committed by another. Now,
But for felony
Tom-
murder, is that required? The two, you said the intent and doing some act. I mean, are there a lot of felony murder cases in which the individual who's convicted of murder under a felony murder theory did not intend for the death of the victim, nor did he or she perform any act to assist? It's simply the fact that the death occurred in the perpetration of the felony.
Your Honor, the directed specifically to felony murder, this whole business with the house and escaping from the house was an independent act. The vehicle which the robbers, of which Mr. Williams was not one, was used in the escape, crashed a long distance from the pawn shop that was robbed. After the vehicle crashed, one of the occupants, presumably Mr. Gordon, the driver, ran from the vehicle into a house where he committed the murders. A good bit of time after that, and there was testimony by someone that there were 100 police officers in the area by that time. So for 100 officers to gather, it must have taken a considerable time.
Well, that wasn't, we don't know. You don't know, the Polk County Sheriff's Department could have a team ready to roll within minutes. But I have a question. You said this was not an independent act, but that's a matter of opinion. Did the trial counsel below ask for the independent act instruction?
There was no independent act instruction, if I remember correctly.
Okay, so then the theory becomes you could maybe argue it to the jury because nobody objected, but it becomes a jury question whether there was an independent act or not, that your client could say, I had nothing to do with it. But we don't have the client's version of the facts. And also that goes to the weight, not the sufficiency of the evidence. And I think you made a distinction in the brief between weight and sufficiency. I don't know if you want to address that further.
Your Honor, what we have here.
Judge Valenti, do you mind if I interject for a minute? I just want to make sure we're on the same page.
Please.
Mr. Cousin, my understanding of the record was that the independent act instruction was given.
You're probably right, Your Honor. I apologize.
Okay, that's right. Go ahead and answer Judge Valenti's
To
question.
be honest, I wanted to answer. I thought it was given, but it may not have been requested. So if that's important to Mr. Cousin, I wanted to let him say so.
Okay, sorry, I understand.
Your Honor, the real problem with associating Mr. Williams with these murders is that there is no evidence at all that he was in the vehicle when it crashed. It's simply not there.
Okay, what did they find his DNA on the gloves in the car? Wasn't he found a
Yeah.
position of rings?
Let me address.
In the burglary?
Wasn't he found hiding in the vicinity of the crash?
He was found hiding at least a quarter mile from the crash the following day. We do not know exactly how far he was when he was found hiding, because the address that was given for the place that he was hiding could have been either an east or west address on that street.
So let me, okay, so it was at least a quarter mile away. So what you're saying is, essentially, let me understand if you're saying, if we find there was inadequate evidence to establish that he was still in the car, because he admitted to being in the car at one point, if he still was in the car at the time of the crash of the getaway vehicle, then there was insufficient evidence to show that he could be charged with felony murder for the death of the occupants of the home perpetrated by Mr. Gordon. But then that still doesn't answer my question. If we were to find otherwise, if we were to find that he was still in the crash, and let's say we were even to find that there was a sufficient evidence of, attempted murder on the law enforcement officers because he was one of the ones that fired the weapon, then what is to stop then what is the rationale for finding insufficient evidence that he could be charged for the murder of the occupants of the house based on the fact that they occurred during the perpetration of the armed robbery or the escape therefrom?
Your Honor, the evidence, which we should not because it's circumstantial evidence, but I'll come back to that. But if we stack the evidence and we say, well, he must have been in the car when it crashed because he must have been in the car when it left the scene of the robbery, and therefore he was part of the robbery, then we can make that connection. But the connection is just too far removed, and secondly, independent act. We've already addressed that. Now, one thing that Your Honor said that I think I should address, and that is the rule in Clay versus State, which is which is cited in the brief. A defendant does not waive the arguments made in the motion for judgment of acquittal at the close of the state's case by subsequently introducing evidence. Now, the only evidence that the defendant, Mr. Williams, was ever in the car was his own testimony that came in the course of his defense case. Of course, the motion for judgment of acquittal goes to the state's evidence, and Mr. Williams' testimony, of course, was not in evidence at that point.
But
now,
the standard against you in this case, on the review of a denial of a motion for judgment of acquittal, the facts have to be taken in the light most favorable to the state. And there are facts there that could go either way, but if you're required to take them in the light most favorable to the state, how are you going to prevail and do the standard?
Your Honor, the only evidence that Mr. Williams was present at the scene of the robbery was circumstantial, and it came from the gloves. Now, two people testified who were present at the robbery, Mr. O'Brien and Mr. Soto. Mr. O'Brien did not identify any of the robbers ever. Mr. Soto identified a man named Jovan Lamb, who he knew previously, when he reviewed a video recording taken from the pawn shop. There was no direct evidence at all that Mr. Williams was present. The circumstantial evidence.
But before you repeat that phrase, didn't Bush v. State change the standard on circumstantial evidence to the defense detriment?
I'm not sure.
It's easier for the state to get past that hurdle.
I'm not sure if it changed the evidence to the defense detriment. In this case, it changed the standard of review. But under either standard of review, we get to the same result. The circumstantial evidence here.
I want to let you know you're at the 5-minute mark, by the way. You can continue to answer, but I didn't want to deprive you of your second close.
I'm going to ask for some more time then, please. But The circumstantial evidence had to do with gloves. There was a pair of green rubber gloves that was found outside the crashed SUV. An FDLE analyst looked at the DNA on those gloves, said the gloves matched Devonnery McCune, who was another perpetrator, apparently. Another pair of green rubber gloves came into evidence as State's Exhibit 69, the left glove, and State's Exhibit 70, the right glove. Now, the analyst was shown only Exhibit 69, the left glove. She was not shown Exhibit 70. I don't know why, but she wasn't. She said that the green glove, Exhibit 69, contained a mixture of DNA, and one of the individuals in the mixture was possibly the defendant. Now, the problem with that is, first off, there is a mixture of DNA, but we don't containing defendant's DNA, but we don't know how the defendant's DNA got on the glove or where it got on the glove. We can infer that the defendant had worn the glove, but there are obviously some other possibilities. Someone else wearing the glove may have touched the defendant.
Let me interject a time problem. You're into your rebuttal time, and I've given you some extra time. If you want to stop now, I'll give you the full 5 in rebuttal, or you can keep going, and I'm going to chop into your rebuttal time. What do you want to do?
Because this is important. So we can infer, but it is not conclusively established that they wore that glove. Now,
didn't the testimony say it was like 780 million times more likely that it was him than an anonymous person?
The testimony was, quote, "This is a mixture of two individuals, Mr. Williams and an unknown individual. Then the sample originated from the two unknown individuals." Okay?
Right. So it's 780 million times more likely that it was a known individual, Mr. Williams, than that was an unknown individual, the second individual's name.
That's not what the testimony was. The witness did not attempt to quantify the likelihood that the defendant's DNA was part of the mixture. She said that it was more likely 700 billion times. I don't know where that number comes from. That's more than the number of people on the planet, that the sample came from Mr. Williams. The problem is that if Mr. Williams' DNA was in fact on the glove, we don't know when or where the DNA came to be on the glove. There is no evidence that Mr. Williams was wearing the glove at the time that the robbery occurred.
Well, Judge Valenti talked about the change in the standard after Bush, and it seems like that would be a better fit for an argument incorporating the concept of the defendant's hypothesis of innocence, which is that, well, my DNA got on the glove when I was, mixing crack cocaine or whatever it was at the apartment, and somehow the glove got into the car. But here under Bush, that even though it's circumstantial evidence, for motion for judgment of acquittal, the court's not required to take into account the defendant's hypothesis of innocence.
No, Your Honor, that's true. But the opinion in Bush did not address stacking of inferences. Here we have to stack at least 3 inferences to get from defendant's DNA on the glove to defendant participated in the robbery. First, we can properly infer that defendant touched the glove at some point.
Well, is that an inference? Is that how we treat a DNA testimony, that it's 700 billion times more likely that it was his DNA than anyone else's? I don't know that that's an inference that we consider when we consider stacking inferences.
No, Your Honor, that's not the 700 billion has nothing to do with the inference. If we assume let's assume, for the purpose of this argument, that the defendant touched the glove at some time. Now, that's an inference because the DNA could have gotten on the glove some other way besides the defendant touching it. But that does not establish that the defendant touched the glove at some relevant time. The defendant may just as well, from the evidence, have touched the glove.
Councilman, I don't mean to interrupt you, but if I don't, you're gonna have zero time. Right now, you've used up every bit of your time. So I'm gonna cut you off. I think you've made your point and we've read your brief. I will give you 2 minutes on rebuttal, but I'm gonna give the state a chance now.
Thank you.
Thank you.
Good morning, Your Honors. May it please the court, Chelsea Sens for the state of Florida. It's undisputed here that the armed robbery and the subsequent crimes occurred and that appellant was the person that was apprehended inside the shed. So the only question was whether appellant was that fourth suspect involved in the armed robbery. Judge Atkinson,
well, do you mind if that is a question, and we've been talking to Mr. Crosman about it. But let's assume that he was. My question is, once they split up and it was every man for himself, assuming that, Mr. Williams was among those who departed the car after the getaway car crashed, can it be considered still part of the escape? Can it be still considered part of it in the perpetration of the armed robbery or the escape if at the time Mr. Gordon killed the deceased individuals in the home, it was every man for himself? In other words, in the car, for instance, while they were still firing at the cops, that was part of the collective action of escaping from the robbery. But how can it still be in the perpetration of the robbery if by the time those individuals were killed, the robbers had already dispersed?
Absolutely, Your Honor. It absolutely can still be considered in the course of escape. As you said before, the felony murder rule allows for conviction for murder where a co-felon commits murder during the commission of or the escape from the underlying felonies. In this case, all four of them bailed at the same time, but it was a continuous act. They robbed the pawn shop, got in the car, fled, attempted to murder the law enforcement officers. The car crashed. It's not like they parked at a house when they weren't being pursued and then they left to go to their own homes. Here, they were being pursued. They crashed into a ditch because they were being chased by law enforcement. When they crashed, law enforcement moved in on them. They surrounded the area. They put up roadblocks, and all four of the suspects were still trying to flee and evade law enforcement in one continuous motion. Just because they didn't run the same direction doesn't mean that they weren't still escaping.
You talk about a series of crimes. So could the murder have been in conjunction with a crime that occurred after the robbery? Now they're doing, let's say, trying to shoot police officers, trying to escape. There's a series of crimes. At some point, the last crime, the murder, may not necessarily relate back to the first crime, the burglary, but it's part of the chain of events. So why can we not look at an intervening felony as the murder relating to that felony? Is there a distinction there?
Well, regardless of whether we consider the armed robbery or the attempted murder of law enforcement as the underlying felony, both are eligible as underlying felony for felony murder. So if, say that there is a temporal break between that first robbery and the attempted murders.
Well, was there a special jury instruction given that would have made the distinction?
I believe the jury instruction was that if the murders occurred in the course of escaping the robbery or the attempted murder of the law enforcement officers.
Okay.
So regardless of which underlying felony we use.
And there was no objection to that. All right, thank you.
Do we need, is there a deficiency in the evidence because we don't know when the murders of the residents occurred? Because if my understanding of the record is accurate, the car busted through the garage in the morning, like hours later. Am I incorrect? In other words, we don't know when the occupants of the home were murdered. Is that correct?
Your Honor, my understanding of the record was that when the car crashed, Javon Lamb and appellant ran one direction, Mr. McCune ran another, and Mr. Gordon ran another, and that by the time Mr. McCune was apprehended, which was moments after the crash, Mr. Gordon was already crashing through the garage door. So my reading of the record, it was within minutes after the crash that the murders occurred, because officers found the
so we can assume from that the murders of the residents of the home happened within minutes of the crash of the getaway car?
Yes, Your Honor. I would say within minutes, according to the record. It was the next morning that the appellant in this case was apprehended. I'm sorry?
I just said what you said. The appellant was apprehended. Sorry for interrupting.
Yes, Your Honor. But there was a perimeter set up immediately around the area, and there would have been, counsel argued that we don't know how far away the house was that he was found in. We don't know how, necessarily that he bailed from the car, but a perimeter was set up immediately. And if you look at the exhibits with the maps, I can't remember exactly which exhibit it is, I apologize, but there is one exhibit that does show the house that he was found inside the shed and the crash scene, and it's very close in distance. I believe it was the house immediately behind the field that he was located in.
I wouldn't mind you addressing though you talked about the chronology issue, but what about the kind of geographic location issue with regard to the perpetrators? In other words, they dispersed, every man for himself. In other words, there was a case that I looked at, and I don't know if it was in the brief, I can't remember, I apologize, but in which there was a crash that happened later, but and an officer I think was killed in the getaway, but they were all still in the same vehicle. And so the debate in that case was whether that crash, was in the perpetration of the crime or its escape. Here, they were not all in the same vehicle. So is it a problem? Is it a problem for a determination that there's sufficient evidence to prove that the murder that occurred in the perpetration of the underlying felony if the perpetrators had all dispersed?
No, Your Honor. In this case, there wouldn't be a problem because, as I said before, it wasn't like the perpetrators decided to go home, hold into their garage, and left for the night. They were still being apprehended. The reason that they crashed and the reason that they dispersed was because they were still being apprehended by law enforcement officers. When they crashed, the officers that were apprehending them, that were chasing them in the cars, and the ones that had started the perimeter moved in on them and continued to chase them. Mr. Gordon was actively being chased when he entered the home of the victims to murder them. So there was no break whatsoever. And just because they ran in different directions doesn't mean that they weren't escaping from the commission of either the robbery or the attempted murder of law enforcement officers.
In the interest of time, I'm going to digress again. The evidence suggests that the structure in which Mr. Williams was apprehended was not a dwelling. If we assume that to be the case, because it was a detached shed, it was not like a lean-to against the side of the house. Why shouldn't we reverse for there to be at least a correction of the judgment and sentence? Because could you address that? Sorry.
For the burglary count, Your Honor, yes. Absolutely. So he was charged with burglary of a dwelling, and as you said, he was apprehended within the shed. First of all, that argument was not preserved below, so it's looked at by this court under fundamental error standard. And the only way for fundamental error to occur in a sufficiency of the evidence circumstance or sufficiency of the evidence argument is if no crime at all occurred. And
so this seems tailor-made, but I'm not sure. But maybe you can elucidate what that means in the case law. There was not insufficient evidence, and Mr. Cosden can respond if he believes there was insufficient evidence that any crime occurred, which he may not. I mean, what if it's just trespass? I don't know if that matters. But in the Monroe case, I think was cited, and the court decided that they could find on the face of the record ineffective assistance of counsel for not moving for a judgment of acquittal. And the sentence for the crime of conviction would not have applied to the crime that was actually proved. But could you explain why we should not reverse based on Monroe?
Yes, Your Honor. You should not reverse based on Monroe, because in this case, the definition of dwelling under the statute actually encompasses the curtilage of the home, and this shed was on the curtilage of the home.
Well, I mean,
So-
assuming again, time is limited, so I'm making my own. I'm setting parameters for my own questions here. Assuming that we determined there was insufficient evidence that it was a dwelling, and he's charged with burglary. He's actually convicted of burglary of a dwelling, but it was actually burglary of a structure. Am I misunderstanding the argument of the appellant?
Yes, Your Honor. Assuming that this court would find that it was only burglary of a structure, not burglary of a dwelling, to find ineffective assistance on the face, you still have to go through the Strickland standard. And in that case, you'd have to find deficiency and prejudice. I guess assuming this court found that it wasn't a dwelling and it was a structure, there would be prejudice. But the state's position.
And what's that prejudice? The prejudice is because it's a more serious offense to burglarize a dwelling.
Yes, Your Honor. That the burglary of dwelling is a heightened charge and offense, but it's the state's position, as I said before, that this should only be looked at under fundamental error. And because a crime did occur, burglary of a structure, and actually the defense concedes in their brief that burglary of a structure occurred, not burglary of a dwelling. But this, again, it's the state's position that under the definition for burglary, curtilage has been interpreted to mean that enclosed space of grounds and outbuildings within the immediate surrounding structure. And in this case, the shed was directly butt up against the house, and it's state's position that would be considered part of dwelling.
I'm not sure. I'm not sure if I agree about your assessment that it was butted up against the kid. Can you show where it says that it was actually abutting the residence?
I believe there was photographs within the record that showed there was the house and then a screened-in porch, I believe, and the shed directly to the right of that screened-in porch.
Okay.
But regardless of whether it was butt against the house or not, it was still within the curtilage of the home, and it was that enclosed space next to or immediately surrounding the structure, or immediately surrounding the home. So it would be the state's position that burglary of a dwelling, that conviction should stand, because not only does it meet the definition, but fundamental error did not occur in this case, because at the very least, trespass occurred. So even if it's not burglary of a structure for some reason, at the very least, trespass occurred. And so because there was because any offense did happen, there's no fundamental error in this case. I did, if that answers your question, Your Honor, I wanted to just address a few things that this court asked during the defense's argument. It is my recollection, Judge Valenti and Judge Atkinson, that the independent act instruction was given to the jury, and the jury did reject it in finding that felony murder. So because that act was given and the jury did reject it, this court should affirm that felony murder conviction, because the facts and evidence taken the light most favorable to the state, because that is the standard we're looking at on appeal, taken the light most favorable to the state, that evidence does satisfy the elements of the crime. One moment. I did want to address too the gloves, the evidence as to the gloves and the DNA within the gloves. There is, admittedly, in the record, it's confusing. And I believe if you look at the record as a whole, you can tell that there's actually a scrivener's error when there's, with the testimony as to the gloves. The left and the right green glove that were found in the front seat, the left glove on the console and the right glove on the floor, were State's Exhibit 69 and 70. That left glove had the mixture of DNA, and that mixture contained appellant's DNA and another person's DNA. And Mr. McCune was excluded. He was the only other person wearing green gloves during the robbery. He was excluded from that mixture. That right glove is the glove in question here. And if you look at the record as a whole, Detective Atkinson testified on transcripts 1045 to 1046, the gloves were admitted into evidence through him, exhibits 69 and 70. And then when FDLE analyst Angelo testifies, the state says, I'm going to show you what's been introduced into evidence as exhibits 45, 69, and the record says 71. It's the state's contention that 71 is actually a Scrivener's error or typo. Because when she describes the evidence, she says the DNA on the right glove matched appellant, the DNA on the left glove, that was the mixture. When the court recalls the evidence during JOA, during the argument, the court recounts the evidence as testimony regarding the DNA results, specifically that the left glove came from the SUV, states exhibit 69. The left glove that came from the center console had the defendant's DNA or matched the defendant's DNA profile. And then there's another Scrivener's error where the court says states exhibit 17, which the state would say is supposed to be states exhibit 7T. The right glove also came from the center console. It was a mixture and the defendant's DNA was included. So the court recalling the evidence, and the court who was sitting there seeing the actual gloves in person, seeing those physical, seeing that it was the green glove that the witness was testifying to, the court recounted that evidence as being about states exhibit 69 and 70, those green gloves, not the gray and black glove that was exhibit 71. And then during closing argument, the court also, the state says that the third suspect also wore the green gloves. And again, in referring to states exhibits 69 and 70, those green rubber gloves are consistent with what the suspect appears to be wearing. The gloves were recovered from the center console of the SUV. And we heard testimony from the analyst that both of these gloves have the DNA of our defendant. And there was no objection to that testimony. There was no objection to facts, found evidence. The defense counsel had no problem with it. So when you look at that record as a whole, it appears that there is just a Scrivener's error in our written record, that everyone in the trial knew which exhibit they were referring to because it was actually physically being held up. So it would be the state's position that the glove that had appellant's DNA was that green glove. And that green glove is shown during the robbery, that fourth suspect is wearing it during the robbery, and it's found with his DNA, with appellant's DNA within the vehicle. So that evidence would link appellant to the robbery as well. And I just want to address really quickly as well, the appellant argues that there was no evidence other than the gloves to link appellant to that robbery, but that isn't the case. I apologize. When appellant's challenging that denial of his motion for judgment of acquittal, he takes each individual offense in a vacuum. And he discusses only the evidence directly connected to that one charge, but each crime here builds off the other. So you can't parse out a specific crime in this case. You have to look at the facts as a whole when you're deciding these issues. And here you have video surveillance of the robbery showing that fourth suspect carrying a silver handgun. And then that same silver handgun with 3 spent shell casings is recovered in the passenger seat of the SUV where appellant was seated during the escape and where the shots were fired at Sergeant Smith. During the robbery, that fourth suspect also wore the cream colored jacket with the fur-lined hood. He wore a white hat, green gloves, dark pants, and dark shoes. That jacket was found on the ground just outside of the SUV where it crashed. The white hat and green gloves were recovered inside that passenger compartment. The DNA analysis confirmed the right glove and the left glove contained his DNA. And then when he was located inside the shed, he was shirtless. He was wearing black pants and dark boots that matched those worn by the robber. In the footage, he was wearing a gold bracelet stolen from the pawn shop. He had cash in his pocket, and he had 6 rings that were confirmed to be stolen from the pawn shop hidden in his sock.
When you say they were, the jewelry was confirmed to have been stolen, what's the evidence?
Yes, Your Honor. So this is another situation where you have to actually look at the record as a whole, because what happens is when they originally introduced the rings into evidence, they're introducing them as states 10 and 11 because they're introducing the physical rings. So we don't have those in our record because we don't have the actual physical rings in our record. But those are introduced as states 10 and 11. And you can see that in the supplemental record, page 289. It's the exhibit list. So photographs, the actual rings were admitted as states exhibit 10 and 11. during Eric Fritch's testimony on page 528 of the transcripts, he was asked if he had an opportunity to compare the jewelry to the audit that he went over. And he says, yes, I did. And they asked, were you able to determine based on the characteristics of the jewelry that these items of jewelry were those taken from the pawn shop? And he says, yes. So this is again confirmed on transcript 1274 when the pictures were admitted into evidence as State's Exhibit 134 and 135. And the exhibit pictures are on our supplemental record on 381 and 383.
Just so you know, you've used up your 20 minutes, but I'm giving Mr. Constant an extra 2 minutes. So if you need extra time, I'm going to limit you to an extra 2 minutes, and then we're going to give him a chance. Okay?
Okay, Your Honor. I think that I'm okay. Do you have, does this court have any further questions they want clarified from the state?
Well, you can finish your thought about the, whether the rings found on, anyway, if you want to finish your thought about I did ask the question about what the evidence was that that those were the actual rings.
Yes, Your Honor. So as I said before, I didn't finish that thought, I'm sorry. State's Exhibit 10 and 11 were the physical rings. They were confirmed by Eric Fritch to be the rings that were taken from the pawn shop. And then they were introduced, pictures of those rings were again introduced by later witnesses as the rings that were taken from appellant. And the rings that were taken from appellant are State's Exhibit 10 and 11, as well as State's Exhibit 134, 135, and 770. So all of those exhibits are the same rings that were taken from appellant, and those rings were confirmed by Eric Fritch to be the rings that were stolen from the pawn shop. So if you connect the dots based on the evidence and whether there was physical evidence or the picture evidence, you can see that those were confirmed to be stolen from the pawn shop.
All right, you've answered the question, but did you need a minute to wrap up? Anything else?
Yes, Your Honor. Just the state's position is that all the evidence taken and considered together in a light most favorable to the state proved that appellant's involvement in the robbery and the subsequent offenses. It was sufficient to deny the motions for judgment acquittal on all the challenge counts, and this court would ask, the state would ask this court to affirm appellant's convictions for all of the offenses.
All right, you brought it in under the wire. Thank you. Mr. Constant, I gave her an extra 2, which she didn't quite use, but I'm going to keep you to the 2 minutes that I did give you extra. All right, you can begin now.
Thank you, Your Honor. As to the jewelry, Mr. Fritch identified the rings by comparing them to a list of items that had apparently been stolen. He did not state, and no one stated, that the rings, or for that matter, the bracelet, or for that matter, the cash that was found with Mr. Williams was actually taken from the pawn shop. Nobody ever said these rings were stolen in the robbery.
Even if we were to discount opposing counsel's connection of the dots, if we weren't convinced by that, was the fact that he was apprehended hiding in a shed under a tarp with a bunch of jewelry stuffed in his socks, circumstantial evidence that the rings were the same ones that were stolen?
No, Your Honor, it's not. The only way we could establish that the rings were the ones that were stolen is by some witness identifying them as the rings being stolen from the pawn shop. Either Mr. O'Brien or Mr. Soto could have been shown the rings, but they were not. Let me come back to the shed. The witness who found the defendant in the shed said that the shed was at 1325 Lee Jackson Highway. The witness did not state whether that was East or West Lee Jackson Highway. West Lee Jackson Highway would have been about a quarter of a mile from the place that the car crashed as the crow flies, but there was a lake between those two places, so it would have been a greater distance on the ground. East Lee Jackson Highway would have been well over a mile away. We don't know which it was.
Mr. Constant, I hate to interrupt you, I really do, but I know you'll go on forever if I don't use the clock. you're at 2.5 minutes, so I've already given you some additional time in addition to the extension. So I'm going to ask you to take 30 more seconds to just sum up your last compelling thought.
The shed was not established to be a dwelling. There was no evidence that it was. There was no evidence that the shed was within the curtilage of a dwelling. And counsel's comments about evidence as a whole are interesting, but we have to take each item of evidence. Therefore, I would ask this court to reverse the convictions and to remand the case.
Okay, that'll be the last word. Thank you very much. You both did an excellent job. You're free to exit or you're free to watch on YouTube. We're going to call the next case.
Thank you, Your Honor.
Thank you.
And we're actually going to flip out, so we're not leaving the room because Mr. Ross